Imagine two people experience exactly the same accident. Both go to court. Both want compensation. But depending on the country, the judge might use a completely different method to reach a decision. How is that possible? The answer lies in the two major legal systems used around the world: civil law and common law. And understanding the difference is easier than you might think. Let's imagine you're shopping at a supermarket. You slip on a wet floor, break your arm, and decide to sue the store. The important question isn't only whether you were injured. The question is, how will the judge decide who is responsible? The answer depends on which legal system the country follows. In civil law countries, judges start with written laws. These laws are organized into detailed legal codes that explain rights, duties, and responsibilities. When a case arrives, the judge searches for the legal rule that best applies to the situation. Then, the judge compares the facts of the case to the requirements written in the law. If the legal conditions are met, the decision follows. Think of civil law like following a recipe. The law provides the ingredients and instructions. The judge applies them to the situation. Civil law is the most widely used legal system in the world. Countries such as Germany, France, Spain, Italy, Japan, South Korea, and many others rely primarily on civil law principles. Although every country has its own unique laws, they all share the idea that written legislation is the primary source of legal authority. Common law takes a different approach. Instead of starting with a legal code, judges often begin by looking at previous court decisions. The idea is simple. If a similar dispute was decided before, courts should generally follow that earlier decision. This helps create consistency and predictability. Rather than asking, "What does the code say?" the judge may ask, "How was a similar case decided in the past?" This principle is called precedent. A precedent is a previous court decision that guides future cases. For example, if a court ruled years ago that a business owner was responsible for a certain type of accident, judges may use that decision when similar situations arise later. This creates a growing collection of legal decisions that help shape the law over time. Common law originated in England and spread to many countries through British influence. Today, it forms the foundation of legal systems in countries such as the United States, the United Kingdom, Canada, Australia, and New Zealand. These countries still have written laws, but court decisions play a much larger role than they do in most civil law systems. So what is the biggest difference? Civil law relies primarily on written legal codes. Common law relies heavily on previous judicial decisions. In civil law systems, judges apply the law. In common law systems, judges apply the law and also consider how similar cases were decided before. Both systems aim for fairness. They simply take different paths to get there. There is no universal winner. Supporters of civil law like its structure, clarity, and predictability. Supporters of common law appreciate its flexibility and ability to adapt to new situations. Both systems have strengths. Both systems have weaknesses. And both have successfully governed societies for centuries. Whether a country follows civil law or common law, the goal remains the same: to resolve disputes fairly and provide justice. The next time you hear about a court case from another country, remember that the legal system behind the decision may be very different from your own, and that difference can completely change how justice is delivered. If you enjoyed this explanation, leave a comment telling us which legal system your country uses. And don't forget to subscribe for more simple explanations of law, rights, and legal systems around the world.